In the studios, we've just been joined by the country's Attorney General and Minister of Justice, Alpha Cisse, who is here to talk about the review of the 1991 Constitution, updates on the recommendations and implementation of the Tripartite Committee's reports, and his plans for the judiciary, among other things. Good morning, AG, and it's a pleasure having you as always.
Thank you. Good morning. It feels great to be here.
You've had from the intro, of course, a barrage of things to be discussed. But first off, help the public understand, where are we as a nation in terms of a review of the most talked about 1991 Constitution?
Thank you. First, before I talk about the 1991 Constitution and the process of taking that review process to conclusion, first I'd like to apologize, to you all. I think a few weeks ago I was supposed to be here, and a few things came up at the very last minute, and so I could not make it. So apologies to you, and then to the viewers as well. I'll definitely do better next time in managing my time.
Thank you for that, and your apology is accepted.
Thank you, thank you. So yes, for the review of the 1991 Constitution, so first I think let's take some steps back. We need some background or context here. The review of the 1991 Constitution is a process that has gone on for more than 20 years. So, when I talk about it, I like to provide that context so people understand that it is not a new process. Some people have asked about, what's the constitution of the review committee. There is no review committee right now, and I take this more than 20 years back to say, when we signed the Lomé Peace Agreement in 1999, there's a clause in the Lomé Peace Agreement in which government made a commitment to review the 1991 Constitution. And then we had the Truth and Reconciliation Commission that followed the end of the conflict. And one of the key recommendations in the Truth and Reconciliation Commission's report was the need to undertake wide consultations across the country and review or revise the 1991 Constitution, and to make sure that it reflects the views and aspirations of the people of Sierra Leone for a democratic society. And so government made a commitment to implement several recommendations in the TRC report. So what the late President Kaba did just after that report was to set up the Peter Tucker Constitutional Review Committee. It was a small committee, conducted consultations, and submitted a report. But by the time the Peter Tucker Committee concluded its work, late President Kaba was already out of office, and we had former President Nkrumah. So the Peter Tucker Committee submitted its report in 2007 to former President Nkrumah. But after examining the report, the former president thought it fit to constitute a wider committee that will undertake more extensive consultations across the country. That is how we got the 80-member Justice Edmund Cowan Constitutional Review Committee. And that committee moved across this country, had more than 10,000 consultative processes, had hundreds of position papers from MDAs, from political party actors, from civil society, from ordinary citizens. And then that committee submitted its report to former President Nkrumah in 2017, having conducted its work from 2013 to 2017. And then there was the white paper, which we call the first white paper issued by the government of former President Nkrumah. Accepted some of the recommendations, but not so for several others. But then the process stalled there, or we'll say after that, 2017 and 2018, that was a short window, and then there was a change in government with President Bill. And President Bill made a commitment to complete the constitutional review process. And so instead of reinventing the wheel, instead of starting a new process, President Bill said, let us go to the report that was submitted by the Cowan Constitutional Review Committee. So, I say this to let members of the public know that the process we are trying to take to conclusion is based on the work done by the Edmund Cowan Constitutional Review Committee, not based on any new committee. And so there was a second white paper in 2021. And that white paper accepted more recommendations. We say it was an upgrade to the 2017 white paper. So now what we have is this sitting right now in the Office of the Attorney General and Minister of Justice. We're trying to work on the technical details, which will include drafting constitutional instruments and taking those to Parliament. And then, of course, because our Constitution says if you touch certain entrenched provisions in the Constitution, then you have to take it to a referendum. It goes to the people. There will be a referendum on the Constitution that will have out of this 1991 Constitution. So that is really where we are, working on the technical details for completion of the process.
But how soon will that be done? Of course, the referendum. How soon? Because the public is still in a haste taking into account. Yes, we have fine laws in the 1991 Constitution, but as you rightly mentioned, they require review. But how soon are we expecting the referendum? Most when it touches on some entrenched clauses in the Constitution.
So on the timing, we are working on a calendar, which we will roll out to members of the public. But the point is that in even putting this calendar together, we want to make sure that we are consulting. And so there will be discussions with political party representatives. There will be discussions with civil society. Those discussions have already started. When I was Deputy Minister of Justice and managing this process, I had consultative meetings with civil society, with journalists, with political party representatives, in which I explained the process and laid out what the proposed roadmap is. Now, of course, the calendar itself, I will say it's not written in stone. And so a concrete calendar will be developed out of these consultations. Because we want to be very transparent about this process. We want to make sure that the process itself is inclusive. That at the end of the day, we'll have a constitution that the people of this country have accompanied. That these people of this country can really own and say, this is our constitution. And so that is why, you know, in taking the constitutional review process to completion, we have said the general language is to say it's our constitution. We want people to call it a Nawi constitution. And so we'll roll out this calendar very soon. It's something that members of the public will really embrace and be involved in.
Mr. Minister, there is one thing that is getting the public confused. The Constitution is the ground of the land. And whatsoever is in the Constitution, no other law supersedes same that is in the Constitution, save for the Anti-Corruption Act, its amendment that now gives the Commissioner the prosecutorial power as a result of the amendments, the Constitutional Amendments, Act number 1 of 2008. But now we've seen some sections within the Constitution, say for instance, the jury. It's been seen a ways to get jury off the Constitution. How is same done when in actual fact we've heard of an amendment to that section that gives that power to the judges in the execution of their duty?
Well, of course, that is not the only provision that will be affected. Okay. Yes, whenever we enact legislations, for some of these legislations, there are implications for constitutional provisions. You will remember the debates around dual citizenship. Right. You know, when it was argued by some people that a corresponding amendment had not been made in the 1991 Constitution. We say the same thing for the abolition of the death penalty. The death penalty was abolished through the Abolition Act. But then, in the Constitution itself, Section 16, which talks about the right to life, you know, gives an exclusion wherein, you know, say, except if it's, you know, in the execution of an order of a court. So you'll have to amend that. These are all the things that this constitutional review process will take into consideration. So yes, we have had the Abolition Act. We will make sure that there's a corresponding amendment, because it was actually recommended by the current Constitutional Review Committee that yes, abolish the death penalty, but also amend Section 16 of the Constitution. So when we talk about working on the technical details of this within the aegis of this, these are really the things that I'm referring to. You understand? You know, combing through to make sure that legislations are reflected in the Constitution itself. If you take Section 27, right, which talks about non-discrimination, But yes, it creates like exceptions, which is of importance to women's groups. I had a meeting with various groups representing issues of interest to women in this country. So we will have a new Section 27 that takes out that that possibility of discrimination. We will make sure that the GIWI Act, for example, which is a legislation, will make sure that that is reflected in the revised constitution, not only in the context of a specific provision that makes provision for the quota system, but also in the context of how we amend Section 27 of the Constitution. So yes, there will be more than just, what you have referenced, and those are the technical things that we'll be working on.
Mostly when we have issues in the country, especially issues that have to deal with politics and even the powers of the president, the conversation comes down to the Constitution and the powers it gives the president. Some of the thought that some of those powers need to be reduced in terms of, that winner takes it all, with all the appointments that, including the Inspector General of Police, would need to get through the president. What would be changing in that area?
Well, I mean, the president himself agrees with you that based on the recommendations in the Cowan report, that executive power needs to be controlled. And so, yes, you made reference to the police. There will definitely be an amendment to police oversight, including appointments. But then, that is why the president has also been keen on amending legislations, that will provide even more oversight, stand outside the powers of the president. So you'll see, you'll note that we have been talking about review of the Police Act of 1964, for example. That is being reviewed right now, and the review in that legislation will be reflected in the provisions in the Constitution. Now, we talk about executive powers. In this country, the Constitution basically says, even though we have a 5-year mandate, but the Constitution gives the president the powers to set the date for the conduct of general elections in this country. That is what has obtained. But it's one of those recommendations that the president himself was keen on accepting in the current Constitutional Review Committee report, that the date for elections not be set by the president, but that in the revised Constitution, we make provision for a fixed date for elections. So that way, dates are not determined at the discretion of the president. That is really, curtailing executive power. It's immense power that the president holds. So I agree with you. I agree with the concerns, expressed by citizens in that regard. The president agrees, and that is what will be reflected in the revised constitution based on the recommendations that have been made.
So the rule of law itself, the questions about how we uphold the rule of law in the country and how citizens get access to justice devoid of their background and political affiliation, it always comes down to the police and the judiciary. But we still have the police head, the IG, Chief Justice, all being, well, the allegations of so many citizens is they aren't independent because they are appointed by the president. So it goes beyond just the IG's examples. Again, what would be changing in these areas? Are we still going to a referendum where it's still put on the table that the president gets to make these appointments, or would those be taken off completely from an appointment, as we always see it has pleased His Excellency the President?
Well, so I think let's be clear. The independence of the judiciary or the police is really not so much tied to the appointment or the mode of appointment.
But there are people who would strongly disagree with you.
Yeah, so, the point is...
instances over
but the point is, Fabian, you can have a situation wherein those appointments are not made by the president, but the institutions are still compromised. Now, check in almost every democratic country across the world. These appointments are made by the president because the president actually is elected by the people. He is given that executive authority to govern the state. And governing the state includes making these appointments in the best interest of the country. Now, when we get to the independence of these institutions, it really boils down to how they conduct themselves. For example, in the context of the judiciary, we're not looking at independence so much in the context of who appoints the Chief Justice, right? We're looking at independence much more in the context of how the judiciary conducts itself. And that is why, you know, when we have developed what we call the justice sector reform strategy, we have laid out several proposals in our strategy as to how you strengthen the justice delivery process, how you close the trust deficit between the public and justice sector institutions, how members of the public will hold the justice system accountable for the way the system conducts itself, how we roll out a system wherein appointments or promotions are merit-based. You know, these are the things that will really help us see the independence of the judiciary. Not so much, you know, who appoints the Chief Justice. Of course, the President appoints the Chief Justice, but we know as provided for in the Constitution, he has to go to Parliament. So there is oversight. Parliament can even decide that that as representatives of the people, they will not approve a particular candidate as Chief Justice, right? So there's that oversight. But we are making significant investment in the broader justice delivery process because we know that that is really tied to respect for the rule of law. Same with the police, right? Yes, the president will appoint the Inspector General of Police, but it's based on the recommendation of the Police Council, which is provided for in the Constitution, right? So there are safeguards there. But then it boils down to how the police will conduct themselves. And that is why in our effort to reform the justice delivery process as part of our justice sector reform strategy, reform of the police is crucial. I just mentioned that now we're reviewing the Police Act of 1964. We have said that we want to strengthen the work of the Independent Police Complaints Board, which is a civilian oversight body. We strengthen that board. We make sure that it has broad reach across the country. We also let members of the public know that it is a complaint mechanism, you know, which by extension is an oversight mechanism for the police. These are the things that are going to help because we know that reforming the police is tied to how we deliver justice. If we reform the operations in the Attorney General's office, we do in the judiciary, but we do not connect that to the police or to the correctional service, it's not going to work. It's like, you know, when you talk about, we say the triple quadrant in project management, right? You know, one is affected, all other aspects of the project are affected. That is how we look at it. It's a chain, it's an entry and an exit process.
Let's look at the tripartite committee, its recommendations, and how that ties to part of the constitutional review process as well. So one of the challenges even before that was between the main opposition, APC, and the ECSL demanding the data for the elections. But ECSL on one hand says constitutionally they are not mandated to do that. So this brings us straight to, again, our constitutional problems. How would the constitutional review process solve this with the recommendations from the tripartite committee?
So good. The president has been very clear that the recommendations made by the tripartite committee will be implemented by government. And let me break this down. When you look at the 86 or thereabout recommendations in the tripartite committee's report, there was an agreement on 80, divergent views on 6, which we all agreed on. I was part of the tripartite committee. And of those 80, the focus of your question is on the constitutional or legislative provisions. So in the tripartite committee's report, there are 17 recommendations that require constitutional amendment. And then there's a proposal for amendment of 40 legislative provisions. It's 26 in the Public Elections Act, provisions to be amended, and then 3 new provisions to be included in the Public Elections Act. And that is where the whole debate about whether the ECSL has an obligation to provide data, which some people will call disaggregated data. When we sat in the tripartite committee, we agreed that there are gaps. And so in order to close those gaps, we thought it would be good to amend certain provisions in the Public Elections Act, which in the future will prevent a disagreement on what the obligations are. And so 26 in the Public Elections Act with 3 new provisions, 5 provisions in the Political Parties Act, and then 2 new provisions. And then you have several other legislations that need to be amended with single provisions. For example, the Cybersecurity and Crimes Act, that we need to review the definition of crimes or offenses. The Sierra Leone Broadcasting Corporations Act, the Independent Media Commissions Act, all of them have single provisions that need to be amended. And then there's a proposal that a new legislation be put together on national youth development, and then another proposal for a new legislation on the independence of the police. So we're taking all of these. For those last 2, the independence of the police, we are already reviewing the Police Act, as I mentioned, so it's going to get in there. The other legislations, they are already subjects of reviews. The Cybersecurity and Crimes Act is being reviewed right now. IMC Act is being reviewed. So we'll get in there and make sure that these amendments take place. But then, as part of the recommendations in the tripartite committee's report, the ECSL has gone through a functional management review. So waiting that process to be concluded. But now, in the AG's office, with help from external actors, we are putting together the various legislations as I've explained them. So for the 17 constitutional proposals that I mentioned, the good thing is that several of them align with the white paper that came out of the Kawan committee's report. Okay. 11 provisions in the white paper touch on elections. So several of them align with those proposals from the tripartite committee. The few that do not align, we've made a commitment that they will be incorporated.
Mr. Minister, already from the white paper, it's as if some recommendations have already been heeded to in terms of new reforms that we've seen over time, one of which speaks to the repeal of the obnoxious 1965 Public Order Act, and similarly so, one also touches on land ownership among many other things, and even the ACC Act. But again, many citizens are concerned about the unbundling of your office, which is the Attorney General and Minister of Justice. How timely is same, the unbundling of that office?
Well, so it's one of those recommendations in the Kawan report, and it's also one of those proposals in the white paper. So it is one of those things that government will take to Parliament when the constitutional instruments are drafted and tabled before Parliament. Now take note that when we go to Parliament, Parliament will have to debate all of these proposals. So one thing that is of note is, as our elected representatives, citizens will also still have the chance to engage their members of Parliament on some of these issues, so that several of these proposals are accepted, including the unbundling of the Office of Attorney General and Minister of Justice. Now the process is Parliament will take a vote. For those provisions that are non-entrenched, with a vote of 2/3 majority in Parliament, they will become law. For those provisions that are entrenched, they will go to a referendum so that the people will take a vote on it. But yes, you can be assured that it's part of the proposals that will be taken to Parliament.
The recommendations in the tripartite reports, one will say, speaks to consolidate everlasting peace in Sierra Leone. But again, over time, we've heard from the main opposition, APC, who still seem very much worried about the constitution of members within the said committee that is set up at the moment. According to them, they believe it's one-sided, as within that committee, I think about 2 of their members are just within the committee. The mayor of Freetown Municipality and that of the one from Bombali. Will you speak to same?
Well, so that is, I think you're talking about the oversight structure that has been set up for implementation of the recommendations of the tripartite committee. No, there's more than the mayor of Freetown. There is more than the mayor of
and even a rep from Parliament.
Exactly. There's a representative from Parliament. But then, we also have civil society representatives on the committee,
and many other sitting government ministers.
Yes, we have government ministers. So, but the whole point is that I think there are a few things we should also consider. When we put together the terms of reference for the tripartite committee, there was really no recommendation that a broad committee be set up to supervise the implementation of the recommendations. The decision was taken by government because, really in the terms of reference, we just noted that the report will be submitted to the president for implementation. But then once it was submitted, first there was a step to set up like an oversight structure within government, but then the president saw the need to broaden it, and so that is how we have representatives from various sectors, including the main opposition, APC. There's also representation from other political parties on this committee. It's just like, the Resolution 4 committee, which, has been looking at reviewing cases that are perceived to be politically motivated, perceived by the APC to be politically motivated. That was Resolution 4 of the Agreement for National Unity. The idea was, if you look at Resolution 4, the language says based on a list that will be put together and submitted to government. But when government received the list, government saw the need to set up a committee. And when we set up the committee, the APC came back and said they will also want to nominate persons to the committee. So the APC nominated 3 additional persons, and government incorporated all of them. So we've been sitting together and reviewing all of these cases, including a decision to discontinue cases for persons on the list who are already in custody of government. That has been taken as a collective decision by the committee. So whether it's Resolution 4 of the Agreement for National Unity or Resolution 3, which is a tripartite committee, government has ensured that there's broad representation in the committees that have been set up to provide oversight.
Former President Tanesbai Nkrumah was allowed to go to Nigeria from according to what came up in court that day based on medical condition. It's been over a year since he left for Nigeria. Will one be in a haste to say he's currently on exile?
I wouldn't call it that. As a lawyer, and even if I decide to take off the hat of Attorney General and Minister of Justice and then just, sit here as a lawyer, I'll go by what is before the court. Okay. And what is before the court is that the former president's lawyers made an application that he be granted leave to seek medical attention in Nigeria. And then, that order was granted. And so, yes, that order has been renewed more than once, but that is what it is. It is an order issued by the court granting him leave to get medical attention out of the country.
Because quite recently, we saw him on social media, he was on meetings. It doesn't seem as if he's sick.
Well, you and I are not medical professionals, right? We can't make that determination. I can say, as a prosecutor, I might decide to use those photographs or videos or I might just make the judgment that I see you right now. I don't know whether you have a medical condition that deserves attention.
Is it coming back to continue his trial?
Well, I mean, take note that the trial has not been discontinued.
Sure.
So this is still a matter before the court. Until that happens, the former president is actually still before the court.
Attorney General, it's taken Sierra Leone nearly 2 decades now. We're still having this conversation on constitutional review process. Your predecessors came to that office, they tried, but we're still here. It hasn't happened. There would be people who are very skeptical and say it's just another continuation of the talk and no action.
No, this is different. So first, the president has always been clear that he wants to conclude this process before the end of his term. His term comes to an end in 2028. That commitment remains. I think what we've had to deal with is a timeline, because take note of that concluding the constitutional review process, yes, it requires broad participation, which we will make sure happens. It also has cost implications, which we are working on. But you also want to deliver a constitution that is owned by the people, and with that, there's no need to do it in a rush. So the president's commitment stands that before he leaves office in 2028, he will deliver this constitution. I've always said it's like running a relay, right? You do baton exchange, from late President Kaba to former President Nkrumah, and then now to President Bio. The only thing is with this constitutional review process, President Bio does not intend to pass that baton to another leader in the post-2028 era. He wants to conclude this process, and I think now more than ever, we have really put things in place within government. We are reviewing the roadmap. We have had an engagement with members of the development community in which the president has laid this out. We have resumed these engagements with political actors, with civil society, and very soon we are going to launch a very massive or robust public information program on the constitutional review process. We have developed that communication, a public information strategy. We are now fine-tuning that strategy, and we will make sure that it is a strategy that is not just implemented by government. It is a strategy that various sectors of Sierra Leonean society can really take ownership of. So yes, we're really making the right investment now to take this process to completion.
It perhaps may be, jumping the gun here, but there has been a lot of money spent in this constitutional review process, and the referendum itself would also have to incur some expenditure. Yeah. What's our best strategy out of this in getting to successfully review our constitution?
Well, I'll put this way. I like the question about what our best strategy is. Now, there are internal consultations. When you look at the current plan, we have non-entrenched provisions. Then we have the entrenched provisions. The entrenched provisions will go into a referendum. Now, when you look at the entrenched provisions, they're not controversial. They're very progressive. So we'll really be making investment, or we'll be spending money on process. Because the Constitution says, for example, Chapter 3 of the Constitution, if you touch any of the provisions in Chapter 3, you have to take that to referendum. It doesn't matter whether you're going back or you're moving forward. When you look at Chapter 3 now and say, the amendments are even progressive, we still have to take it to referendum. When you look at the provisions relating to the judiciary, the Constitution says if you touch those provisions, you take that to referendum. So even when we talk about increasing the number of judges in the Supreme Court, or when you talk about, I like to make reference to like something that you might want to consider as minute, right? Which says, instead of saying inferior courts, we say subordinate courts. That's a provision that will require a referendum. So that is what we're looking at. So basically, you're talking about a process that might be multiple question referendum, which we've never had in this country. You know, you have to look at best practices, right, as to how you frame such questions. In Liberia, just across the border, they had a referendum. It was 4 questions. Now, the current setup will mean we have more than 4 questions. Now, we need to ask ourselves, for example, do you want to ask a single question on Section 16, which really talks about taking out the death penalty, or Section 29, which talks about a state of emergency, but then adding a provision that during the state of emergency, there will be no derogation when it comes to the right to life or the right to be free from torture. Are these single questions that you want to take to people across this country, or do you just want to ask like a single question on Chapter 3, single question on Section 120? You understand? These are the things we're looking at. Or should we say that when you look at the Cowan report, maybe go back to the Cowan report, even increase the number of recommendations, right, that were proposed. And then you bring in the tripartite recommendations, right? And then you issue an updated white paper. Now, taking note that an updated white paper will mean additional proposals that will now be in the revised constitution. And then taking note that there is a proposal that we also develop new chapters. A new chapter on land governance, right? A new chapter on public service, right? A new chapter on national security, a new chapter on the country's mineral wealth, right? These are 4 new chapters that we're talking about coming into the Constitution. You bring in the tripartite recommendations. You add more from the Cowan Constitutional Review Committee, Constitutional Review Committee's report. At that point, would you say, with an updated white paper, the nature and character of the 1991 Constitution have changed so much that you can only now call it a new Constitution? That is the question that we'll have to answer. And then when you say a new Constitution, then you don't need multiple questions. You take that to members of the public, they decide. Do you want a new Constitution or not? It's yes or no. That is how we voted for the 1991 Constitution. And so these are the consultations that will happen and the strategic decisions that we'll have to make.
Well, at this point, we'll have to read out some of the messages on our Facebook page and get the AG's response to those comments. I'll start off with Hossam Conte. He says, current Attorney General and Minister of Justice, Honorable Alpha Sisi, even though you were not in office when the decision was taken by government as Attorney General and Minister of Justice in repealing the death penalty, do you think at this moment it was necessary for repealing the death penalty in Sierra Leone? Moreover, as Sierra Leone is part of the Economic Community of West Africa states, how many West African countries has repealed the death penalty, and even further in the entire African continent?
Osman Kamal says, are you considering to review Chapter 2 and 3, Chapter 2, which emphasizes the political and civil rights of citizens, but no emphasis in Chapter 3, which mention the economic and social rights, of which no emphasis are laid? What's your opinion regarding Chapter 2 and 3, based on the theme of the Constitution? Democracy is somewhat expensive in trying to implement. It requires 2 sons of the soil with no egos of pride and greed. Are you going to review the unicameral parliamentary system to a bicameral system comprising of state elders with innate morale?
Joseph Josiah is asking, is there going to be anywhere in the revised constitution where citizens can take government and government institutions to court for not providing basic services? Example, EDSA, Guma Valley, to name but a few.
Fode Mustafa Toure says, how long will you continue to talk about this review process when you have all the powers to have done it already or today? What is stopping the process? Is it because the president wants to continue enjoying these privileges until his last days?
Hosam Const says, Mr. Attorney General, there are so many cases in court that has taken decades without any verdict, but heard, which involved in the long detention of certain case members. What is your take on such cases?
Swissman says, is there any provision in the Constitution that prevents citizens not to demonstrate when things are going abnormal in the country, especially if the people are experiencing high cost of living and bad governance in the country? And why is it that judges are not answerable to the president, but when the president committed a crime, and if he should be prosecuted by the law, they are the same judges that commence the trial on the president?
Victor Akomengot says, why not draft a new constitution that incorporates both the entrenched and non-entrenched clauses and have a single document presented to the public through a referendum? Doing a piecemeal amendment by having some of the recommendations approved by a 2/3 majority in Parliament will not reflect the will of the people. MPs are most likely to vote on party lines.
Mosdi says, as much as we are all yearning for the review and amendment of the Constitution, we must make sure that the whole country is taken on board. The education part, I think, should be the most critical part. Let's make sure the message is clear and translated in each and every tribe in our country. So when it's time for a referendum, at least a vast majority of the people are informed. The explanation must be clear and precise in all honesty and sincerity.
Lolo Gasparini is saying, Attorney General, could you kindly provide an update on the extradition process that the Dutch government sent to you about Belojos? How far is the process going now?
Usman Prince Sulaiman Kavoni says, how can we stop this woeful detention and hold the police and the court accountable for upholding the law that says perpetrators should be taken to court in 72 hours for ordinary crimes or misdemeanor and 10 days for capital crimes?
My last speak is from Mosdi. He says, I think executive appointments are not our fundamental problems. My own opinion as a country, we need to go back to the drawing board with the main objective of recalibrating our mindset. We must all as citizens make it our paramount responsibility to be patriotic to our country first, rather than being patriotic to our different political parties, regions, tribes, etc. We must have a nationalistic approach in terms of our patriotism, even if we take some of those powers away from the executive. As long as the culture of party, regional and tribal patronage is there, the struggles continue.
Lastly for mine is from Joseph Josa, who says, is there going to be anywhere in the revised constitution where citizens can take government and government institutions? Have you read that one? Yeah. Okay. So you respond, AG.
So thank you. I think a lot of very interesting questions. First, I'd like to say that I want to associate with the last comment that you read, Fabian, which was not really a question, about patriotism, about taking responsibility. I want to agree with that particular viewer's comments, and then to the very many questions. Can citizens take government to court? Yes, citizens can take government to court. But of course, there's legislation that lays out how you take government to court, right? Whilst I've been Attorney General, I've received a lot of notices wherein, you put the Attorney General on notice with a specific timeline. Say, if this is not remedied within this particular period, you'll take legal actions against government. So that is available. But let me try and go through some of the other questions really quick. First question has to do, with whether the death penalty was necessary. Yes, it was necessary. It is the belief of government that the state shall not take the life of another human being. And for me, personally, as someone who has spent my entire career as a human rights advocate, even before getting into government, it's something that I advocated for publicly, that the death penalty should be abolished. And so, yes, I agree. Even though it happened before me getting into this office. I agree with government's position that it is necessary, and government does not intend to go back. That is why we will make sure that there's a corresponding amendment to Section 16 of the Constitution. Now, on Chapter 2. So the thing with Chapter 2 is that, it is that section of the Constitution that we call the fundamental principles of state policy. And then, you have all of these provisions, which, you can call like socioeconomic rights, right? And then, there's always been this debate as to whether they put legal obligation on government, considering that they are driven basically by, most times they are driven by the availability of resources, right? Providing education, health, etc., etc. And then when you come to the end of that provision, it says that, the rights listed here, will not be justiciable and all of that. So it's something that has been debated extensively within government. More so, noting that for the president, he has seen some of these provisions in Chapter 2 as fundamental human rights which government owes the people. And that is why the president was very clear since he came to power in 2018. He's made significant investment in education. You make public education free because it's a right, and government went ahead and reflected same obligation in legislation. So for the president, he's very keen on this. How do we make sure that this right is made sacrosanct in the Constitution, or the investment that we make in health? So yes, there are provisions within Chapter 2 which will put legal obligation on government, as part of this review process. Of course, Chapter 3 already put legal obligations. Chapter 2, of course, is also legal obligation, but it just says it's not justiciable, so you cannot take government to court. For Chapter 3, you can take government to court, right, for these. So yes, these technical discussions that are taking place right now will really look at, whether you make the entire Chapter 2 justiciable, or you take aspects of it, including the investment that government is making into education, into health, and make them justiciable. Citizens taking government to court, I think I responded to that. How long this review process will last, because it's taking too long, I agree. I'm the first to acknowledge that this is a process that has gone on for more than 20 years. Similar, I think the last time I was here, we spoke about the Criminal Procedure Act, a review process that lasted for more than 20 years, but then, there was a commitment to take it to completion, which we have done. And so it's the same commitment that we're taking to the conclusion of the constitutional review process. So if you ask me how long this will last, I'll tell you with certainty that this will happen during the second term of President Bio's presidency. Many cases in court, I agree. I acknowledge that, as a shortcoming in our system. And these are the issues that we're trying to address. I mentioned the justice sector reform strategy. It really includes, one, how we clear the backlog of cases that we have in court. But when we clear that backlog, how we ensure that we don't have additional delays. A situation in which we'll have more backlogs going into the future. And that is why now we are enacting legislations which we will use to hold ourselves accountable. For example, the Criminal Procedure Act will now put timelines, on the conduct of the courts, or our own conduct within the Attorney General's office. So now, of course, when a matter comes before a magistrate, moving from the preliminary investigation system to committal proceedings, the magistrate will have 28 days to commit the matter to court. The AG's office will have 60 days to prepare all indictments, and also provide, make disclosures to the other parties, so the evidence that you're going to rely on. All of this should happen so you don't have trial by ambush. And then, of course, the matter goes before the court, from the moment the person is arraigned before a high court judge to the time that the matter ends. For certain, depending on the gravity of the offenses, everything should be completed, maximum within 90 days or 180 days. Failure to do that, you either discharge the person or you grant them bail, depending on, the gravity of the offense. These are going to eliminate delays. We are also putting in place a lot of reform initiatives. For example, we want to digitize the justice delivery process. We really believe that when we digitize the justice delivery process, we have an e-justice system, which is part of our reform agenda. That's going to make things move really fast, So, because it helps us get rid of paper filing, it helps, various people participate in the justice process remotely. So these are all reform initiatives that are going to help. Right now, I've been in discussions with the Chief Justice. We are looking at how we clear the backlog. We need to increase the number of judges in this country. We need to increase the number of magistrates in this country. And then, of course, we need to provide them the tools. We need to also decongest the court system. The point is that we have way too many cases coming to court, and that is why when we bring in the mediation law, which we are currently doing consultations on, it will really ensure that not every case comes before a magistrate or a judge. For some, you'll have these, handled by trained and certified mediators. You can handle this within a day. It's cheaper, it's less acrimonious, it's faster, and then, of course, it frees the pressure that we have on the court system. So those are all reform initiatives that are in place. Yes, there's been this question of, the right to demonstrate. Yes, the right to demonstrate is a right that citizens have. We just have safeguard measures where, you ought to obtain a permit from the police. The trial of a president, the Constitution makes very clear, while someone holds the office of president, civil or criminal proceedings cannot be instituted against them. And that is, a universal system. It's a universal approach. When, of course, the person leaves office, as we have seen with former President Nkrumah, yes, charges can be brought before them. A single document and not piecemeal goes back to the question that Fabian asked earlier, about how strategic we plan to be about this. These are all issues that we're discussing. Whether we now, just present this as a single document, acknowledging that the nature and character of the 1991 Constitution has changed so much that we'll have to call it a new Constitution. Yes, there's a question about the request from the Dutch government for the extradition of someone believed to be in Sierra Leone, and as you have heard, the Dutch government will say has said that the person has already been convicted or is being investigated for the commission of certain crimes. One thing first, I'd like to lay on the table is that the Minister of Information and Civic Education has done a brilliant job. I'm explaining this to members of the public and been really very transparent, about how government is handling this. The Inspector General of Police has also made very clear that this is a subject of ongoing investigation, and that they have tied a name to a face. Now, where I come in, yes, I'll acknowledge that the Dutch government, as required by law, has served extradition documents on the Attorney General and Minister of Justice. So, yes, I acknowledge that I am in receipt of those documents from the Dutch government. And then what that means, when the Attorney General receives those documents, you study them. The way extradition works is that, one, the crime for which the person has been convicted or is being investigated in that other country must be a crime in the country in which the request has been made. So that will mean crime committed, in the Netherlands. If those crimes were committed, or if those actions were to take place in Sierra Leone, they will also amount to criminal conduct. And then the Attorney General will examine all of it. If the Attorney General makes a determination that there's a basis to proceed with extradition, then an application will be made to the court. So yes, there'll be a legal and political...
When did you receive the letter from the Dutch government?
I received more than a letter. It's a bundle of documents.
When did you receive it?
I received the documents in February. In February, and that's over 2 weeks ago that I received the document. And once I received the document, the Minister of Information and Civic Education made a public announcement that the documents had been served on my office.
So you've explained, you know, the procedure in looking into the documents. That's the theory. The practical aspect is we know that even in Sierra Leone, drugs were not drug friendly in Sierra Leone.
Yes.
So clearly, those crimes, because the information is online from the news, those crimes in Sierra Leone committed would still constitute total crime. So what's next?
So, like, I agree with you, you know, and Sierra Leone has made significant progress when it comes to fighting transnational crimes. You will see that in addition to the accountability regime, persons who have been prosecuted, there's also been an institutional response. I think, you know, you must have seen in the news that we have been able to intercept like entry and exit, you know, stand for drug, with both at the airport and at the seaport, you know, or, you know, even within the road exits, you understand, the borders of this country. Just yesterday, there's news about a vehicle having been intercepted by our police, you know, escaped, and then, you know, by the time it got to McKinney, it was intercepted. So those responses are out there for all to see, you know, transnational crimes, same in the context of human trafficking.
Yeah, so what does the government intend to do with the request from the Dutch government, the extradition request?
So that is where I see...
Are we intending to comply?
So we are examining the documents. So the point is that these are legal papers, right?
Why do you examine as a government? What's the status of Jos Leijdeker's, aka Umaru Sharif, aka Boliyos, this same individual? What's his current status in country?
No, that is for the police to handle. My job is to examine the legal papers. When it comes to...
I ask because what if peradventure, while you're handling this, and we pull some tricks, next thing you know, he's out of the country. It still puts all this extradition requests to null and void, to say. So the suspicion is, are we buying time to let him go?
So the point is that I think we're making conclusions, right?
No, I'm just asking questions.
Yes. No. So here's the thing. I think going by the last update provided by the Inspector General of Police, he made clear that yes, they had made a connection between someone seen in a video and a person carrying the name Omar Sharif. But then they didn't have this person in custody. That is for the police to handle. I think when it comes to whether the person has been located, whether it is in custody, I think, you know, let's get those updates from the Inspector General of Police, and I don't think he has provided any update beyond what he provided. Now, when it comes to my job...
Are we intentionally, as a nation, retaliating for the request that Sierra Leone had made to their government for Adebayo?
No, we are not retaliating. The two issues are not related at all.
But similar.
No.
You have one person who this country considers that has committed some crimes that needs to come and face justice in your country, but is living in that country. It's a very similar situation.
No. So one thing that is very clear is that we will not make this issue a quid pro quo discussion. I think government's position on the conduct of this person called Adebayo is very clear. That is a separate matter that is being handled with the Dutch authorities. And then, of course, you know, the request made by the Dutch authorities in the context of this person that's the subject of our discussion is completely separate. Now, of course, you know, mutual legal assistance, you know, is corresponding obligation that states engage in. We will handle these discussions separately, but I'll tell you for a fact that there is no time wasting on this. There are no tricks being played on this. I take my job seriously, and I will not be taking decisions just based on what's in the media. I will take decisions based on the evidence that has been presented by the Dutch authorities. My team and I will do a line-by-line reading of those documents that have been submitted by the Dutch authorities, and then after reading all of these, examining all of these documents, if it warrants an action from our end, we will take that necessary action. Now, what that action will be, I cannot sit here and say, because we are examining the document. When it comes to criminal conduct, that is why, in fact, I made reference to the Criminal Procedure Act. You know, even when a matter will be committed from the magistrate court, the AG's office will still need about 60 days to examine everything, to prepare an indictment, you know, because doing reviews of these documents and taking decisions on what needs to be done, these require efforts, require sound reasoning, and that is how we will really approach this particular task.
Finally, as we round off and let you go, we saw on the first day of the holy month of Ramadan the First Lady making a heartfelt plea for Hawa Hunt, who is in custody, and that case had been charged to court. How does the Attorney General and Minister of Justice's office comes into play in this? Well,
so the law is very clear in our constitution. Say at any stage of proceedings before judgment, the Attorney General's office can discontinue a matter. And we lawyers will say the Attorney General has like null prosecute powers, you know, to annul proceedings, you know, and not proceed. Now, this has generated a lot of debates, and so I'm really glad that you raised this question as to the First Lady's plea. You know, some people even speculate that it suggests that the AG's office, you know, will take directives from abroad. First, I'd like to state that I have been Attorney General for a little over 2 months. During these 2 months, I have had to discontinue more than 10 cases before the courts. More than 10 I have had to discontinue. Yes, when we talk about criminal conduct, it's a matter for the state, right? But then there are several occasions in which a complainant or a victim of criminal conduct will say that I do not intend to cooperate with these proceedings, or I do not want this matter prosecuted. At that point, the Attorney General will have to make judgment as to whether it's the right use of the state resources for us to continue prosecutions. Of course, there are those criminal conducts, such as sexual offenses, in which the law is very clear, or in which, you know, I'll take a principled decision that whether the victim cooperates or not, whether the victim wants it or not, I will not discontinue proceedings.
Yeah, but you just speak to this one. This is one case in question, Hawa Hunt. What is your intention from the First Lady's plea? Are we going to discontinue that? Should people expect Hawa Hunt walking free? End of the case. This is a specific case.
Yes. So in the context of this specific case, it is my understanding that Hawa Hunt's lawyers will renew the bail application. And to be very clear, is that I do not intend to object to the bail application. But then, noting that the matter had already been committed to the High Court, and then Hawa Hunt has not appeared before the High Court. And so there are legal processes in discontinuing that matter. But if you want me to make a very public announcement on what the position of the office is that one, we will not object to bail application for Hawa Hunt, and then two, noting that you know, the impact of the victim on the victim you know, is now like minimal based on what we've had, and then noting the number of cases that I have to deal with in my office, for which, you know, I need to maximize the use of my resources. I will say in very clear terms that yes, we will discontinue the matter against Hawa Hunt.
Would this constitute as another case of orders from above?
No, it will not be orders from above, and that is why I said, if I just wrap this up, that is why I said, since I have become Attorney General, I have had to discontinue, I think I can count up to 13 cases. All of these 13 cases have had nothing to do with the presidency. Some of these have had to do with criminal conduct against regular people. But when I have looked at the evidence, when I have looked at the amount of work that needs to be done, when I have looked at what the victims have to say or the complainants have to say, I have taken the tough decision of discontinuing these matters. Even today, there are 2 other matters beyond our own which will be discontinued. So it has nothing to do with orders from above, but also considers that the impact on the victim or the complainant is different from what we will perceive it to be, you know. So yes, that is what will guide the decision making, and that is why we'll discontinue the proceedings.
Thank you very much, Alpha Sisi, Attorney General and Minister of Justice, for your time this morning on Wake Up Sierra Leone.